let's talk about self-defense in a criminal case in Massachusetts. So you and everybody else has a right to defend themselves physically from an attacker. If somebody's coming at you with an imminent threat that you believe they're going to cause you harm, you have the right to use physical force to push them back and to keep them at bay, protecting yourself. But that right isn't unlimited. It must be proportional to the threat that you're facing. And proportional just means that the amount of force that you use has to be somewhat in the same ballpark of what you're facing. So for instance, if somebody comes up to you and pushes you, you can't come back and hit them over the head with a hammer. That would be considered not proportional, and that would probably not qualify as a valid self-defense defense. Another issue in self-defense cases is that everybody has a duty to retreat in Massachusetts. What that means is that if somebody is coming at you and you feel that you are threatened by this person, you have the duty, that means the obligation, to try to get yourself out of that situation. So if you can leave and not use any force to repel the attack, you're required to do so. You can't just act out of a sense of anger. If you can escape, you should escape, and that's what the law requires. And I know it sounds kind of crazy because you're thinking, or this is how I think anyway, look, if somebody's the aggressor and they're coming at me, they deserve what they deserve. They deserve what they get. But that's not the way the courts look at it. If you can get away without using force, you need to do so. And if you don't do so, the self-defense defense may not work in your case. Another thing that we need to look at is what's called the castle rule. So we just went over the duty to retreat. So if you can get away, you should get away. But that doesn't count if you are in your own home. The old saying is that a person's home is their castle. Well, that's where this name comes from, the castle rule. So if you're in your home and somebody breaks into your home and is going to cause you, and you believe that they're going to cause you some sort of physical harm, they're a danger to you, in other words, you have the ability and the right to defend yourself without having to retreat. So if you're in your home, you don't have to look for a way out. And that might be a smart idea to do so. That's something different. But legally, you don't have to do that. So if somebody's in your home, you have the right to defend yourself without having to worry about a duty to retreat. So similar to self-defense, there's also a defense called the defense of another. And that's when you step in and protect somebody else who's being threatened by a third party. So let's say you're walking down the street and you see an aggressor attacking or about to attack some other individual. You have the legal right to step in and help that other individual ward off the attack or take care of the attacker. So it's like you're stepping into the shoes of that person, and the same rules from self-defense apply in the defense of another situation. So your force that you use must be proportional so that you can only use as much force as is necessary to stop the attack. And if you think the other person can retreat and get away from that, that's the first course of action that you're supposed to take. So in other words, you're stepping in to defend another just like you would to defend yourself. Also, sort of related to this is what they call the defense of property. So if somebody's trying to steal or damage your property, you do have a right to step in and use physical force to stop that from happening. However, very same rules apply as in self-defense, and really I found that in cases such as this, that if you're defending your property, courts, jurors in particular, are less likely to give you as much of a break in defending your property as if you were defending yourself. Basically, they're thinking that it's property, it can be replaced. If somebody's attacking you personally, obviously your physical safety is in danger. So they were more willing to cut you a break, if you will, and allow you greater leeway to act to repel that physical attack rather than stopping somebody from taking your property. Courts distinguish between using deadly force and versus non-deadly force in a self-defense case. So non-deadly force is obviously anything that's not going to cause the other person to die as a result of your actions. And deadly force is still, it's allowed, but it's in very few circumstances, very limited circumstances. Deadly force is any force that will cause the death of the other person or serious bodily injury. You can only use that in the self-defense case if you are being faced with a similar type of situation where you reasonably feel that your very life is threatened, that this person is going to kill you or cause you significant and serious bodily injury. Another issue that sometimes comes up in self-defense cases is where they're claiming that the defendant, you in this case, were the first aggressor. So if the Commonwealth can prove that you were the one that started the fight, for instance, you cannot rely on a self-defense defense in your case. Because what happens is, the thought is anyway, that if you instigated the fight, you can't then fall back and say, oh wait, it's not my fault, I need to defend myself, because you're the one that kicked everything off, and you should be held accountable for that. Mutual combat is a similar situation where mutual combat is when two people agree to a fight. So let's say somebody calls you out, they're calling you names and they insult you, and the two of you go at it and you're meaning to fight together. If you're fighting under the mutual combat situation, you can't later claim that you were defending yourself, because you actively involved yourself in that situation, and there's a certain assumption of the risk that's associated with that. Having said that, however, it still can come into play. So let's say that there is a mutual combat situation. You agree to fight this other person, and then at some point you withdraw from that. You don't want to fight anymore. You back off, and maybe you're even leaving. If you're on your way out, if you have discontinued your attack, and if you have communicated that you no longer want to engage in this, and then that other person comes at you and you have to defend yourself, that could turn the tables, and that may open up the ability for you to claim a self-defense defense in your case. Similar to that are cases of retaliation. So a person can use self-defense to keep themselves safe, but you can't retaliate against the original aggressor. So let's say somebody comes at me and they're beating me up, and I I push them away or do whatever I do to get them to back off, and then they have had enough and they're leaving. Obviously my blood's up. I'm going to be angry. I cannot go after them. So say they're walking away. I can't go after them and retaliate and hit them in the back of the head and keep the fight going. If I do that, I have now become the aggressor, and I can no longer rely on a self-defense claim, because I am the one who is now retaliating or escalating that situation. Something else I'd like to point out is that sometimes the reputation of the alleged victim, if they have a reputation for violence, can come into play in a self-defense case. And I'll tell you exactly how that works out. So let's say there's a question about who started the fight. So let's say you get involved with a fight with another person, and we're not sure who's the original aggressor. But you want to claim that you were defending yourself. You want to use the self-defense claim. If we can show that the alleged victim has a propensity or has a habit of causing fights, of being involved in fights, of being an aggressive person, those types of situations can come into evidence for us to show that their reputation for this type of behavior is such that it shows that they were the original aggressor. Now, this applies even if you didn't know about their reputation at the time. So let's say you get into a fight with somebody, you don't even know who it is. Say you're out at a bar, you get into an argument, it ends up in a fight. And later you find out that this person has, let's say, a criminal record for assault and battery cases, for domestic violence perhaps, that they threaten people or get into fights on a regular basis. Even though you didn't know that at the time, we can use that under what they call the adjutant theory, that the other person was actually the instigator or the primary causer of the fight. Who has the burden of proof is an interesting aspect of a self-defense case. So in a criminal case, the Commonwealth has the burden of proof beyond a reasonable doubt to prove each and every element of the charges against you. So it's completely on them. The burden never shifts to the defense. So we never have to put on any evidence. You don't have to testify. It's their burden to go forward. In a self-defense case, however, we need to prove and put in some kind of evidence that you are acting in self-defense. So you could testify on your own behalf. There could be witnesses. We may use video surveillance evidence or camera, video from cameras or something like that. In any case, we can put on some evidence that you were acting in self-defense. Once we put that into evidence, it is now the Commonwealth's burden of proof to prove that you did not act in self-defense, that whatever you did does not fall under the protective umbrella, if you will, of the self-defense claim. So they could show that it was not, your reaction was not in proportion to the threat that you faced, that you exceeded the amount of violence that was needed for that particular case, that you could have retreated, but you chose not to. These are the types of things that they may try to put on, but it's up to them to prove that, and to prove it beyond a reasonable doubt, which is the highest standard that we have in the law. So proof beyond a reasonable doubt, the jury has to be convinced to a moral certainty that you committed this crime, and in this case, that you were not acting in self-defense. So self-defense is a hugely important defense that we often use in our cases. It's a little bit tricky, and getting that evidence before the judge or a jury is critical. But it is something that can rely on, and if there is a self-defense claim, that'll get you off the hook completely. If that's successful, you will be completely exonerated or found not guilty as a result.